Well, generally, in most of these cases where you're trying to challenge a will or a trust, you're looking at two primary legal doctrines. One is undue influence and the other is lack of capacity. Undue influence is the idea that somebody has exercised their ideas and thoughts on you and imposed them on you or one of your loved ones to change their will and trust against what they would naturally do. Well, there's two ways to do this in California. Number one, you can prove undue influence directly, and you can also make the other party prove that they did not unduly influence mom or dad or whoever the individual was that was leaving assets to family members. The first way is a little bit more difficult to prove undue influence directly. What you have to do in those cases is show that you have to show facts to the court, to persuade the court, and you have to meet a certain burden of proof in establishing those facts that somebody actually made grandma do something that she didn't want to do, or made your mother or father do something they didn't want to do. Those are harder cases, but you can show them, such as, for instance, you can look at how old was the person when they changed their will. If they're rather elderly, that can lead to the idea that they perhaps were under the undue influence. Was there a conservatorship in place? Did they have Alzheimer's or dementia? Did the family member that got them to change the will or trust, were they living with mom or dad at the time that happened? And so some of those are issues we look to for direct undue influence. The easier way to prove undue influence, and it's not easy, but it's the best way to do it, is to show a certain relationship that the individual that exercised undue influence over the elder had. And for instance, if somebody is a fiduciary, we call that, or has a confidential relationship with the elder, maybe they're an agent under a durable power of attorney, maybe they're a family member that's living with and mom or dad relies on them for their daily living needs. Just being a family member is enough sometimes to establish the confidential relationship. If you can show the person also helped arrange the creation of the will or the trust by driving them to a lawyer's office, calling the lawyer and setting up the appointment, maybe drafting the will or trust on LegalZoom or one of the commercially available websites where wills and trusts can be easily drafted and changed. If you can show that, that's good as well. And then the easiest one to show in most of these cases is that person actually ends up getting more of the assets than they would have had either under state intestacy laws or what the previous will or trust showed in that case. If you can show those three things, you can now shift the burden of proof to the wrongdoer, to the person that has exercised undue influence over a family member, and you can force them to prove to the court the absence or that they did not exercise undue influence over the family member, which is, in our experience, we found it's difficult for them to do.